My Lords, just before the adjournment, I was focusing on various ways in which we say the Court of Appeal should have, but failed to analyse some of the nuances and problems in this case that arise, particularly in relation to the multi-party and multi-contract nature of it. We touched on it earlier this morning, but the starting point we would submit for an analysis that does have to be made, but which wasn't made by the Court of Appeal, is to recognise, first of all, that the Court of Appeal did dismiss the first ground of appeal from Mr. Justice Waxman's decision, which related to, broadly speaking, the Swiss law approach to arbitration agreements, in particular in this kind of multi-party, multi-contract situation. And in that regard, I've only touched on it in passing before, but one has to factor in what I might call the logistics entity question, which I mentioned earlier. That's because the two logistics entities, D9 and D10, were not named parties or signatories to any of the three supply contracts, but were in fact subcontractors under those main supply contracts, so that the first of the logistics company, D9, was the subcontractor of D6 and D7 in relation to each of the Pro Indicus and Ematum transactions, whereas the second logistics entity, D10, was a subcontractor only to the MAM transaction. And that's the situation we've endeavoured to set out in paragraphs 20 to 21 of our written case to elucidate the disparity of parties. Now, it appears to be Privinvest's case that both logistics entities were in fact party to all three supply contracts, despite the fact that those subcontract arrangements, which are said to be the origin of that Swiss law concept that they became parties to the supply contracts, despite the fact that they were only separately parties to two and one of them respectively. It may matter, and it may be important, and certainly one couldn't do the analysis one needs to get to the answer in this case without a proper understanding of which logistics entities are in fact said to be parties to which arbitration clause, and why.
Is this going to be an issue at trial as well?
Potentially, my Lord, because it's not clear. You may have seen that in the bundle there are quite extensive pleadings that are called the Section 9 pleadings, served by both Privinvest and the Republic. And they do set out extensively what the case is about Swiss law and incorporation and the beneficiary principle interference. But they do not elucidate this question. There is stony silence on the part of Privinvest as to which of the two, as to why the logistics entities both are parties to all three supply contracts on their case, and if not, what is their case? So we don't.
What's the assumption on which we are proceeding?
Well, that's where it's rather difficult, because it's not clear to me, at least, whether the assumption is that they are to be parties to both are to be parties to all three, or that the logic is to be followed, which is that they are only supposed to be parties to the ones they subcontracted. And that's why, if you see paragraph 21 of our written case with the second of the ticks and crosses in the table, we have assumed, rightly or wrongly, that the only rational situation one can discern from the Privinvest pleading is that they must be saying that D9 is only a party to the Pro Indicus and Ematum arbitration agreements, because they're the arrangements to which D9 was the subcontractor, whereas D10 is only a party to the MAM agreement for the same reason.
I can't see how you could come along as a party to a contract you had no connection with of any, even indirect kind at all.
Well, you would think that, my Lord, and now our problem is that on the face of the pleading, they say that. They do say it. And they make no distinction between the two. And the additional factor that's relevant there, of course, is that those subcontract arrangements between Privinvest's entities and logistics companies are expressly governed in two cases by English law and have an exclusive English jurisdiction clause. So one of the factors that Mr. Justice Waxman included in his analysis, rightly as the Court of Appeal found, as to the likely presumptive width of the arbitration agreements in the supply contracts, one of the factors is that as between Privinvest and the subcontractors that it says were party to the supply contracts, there were in fact contracts with exclusive English jurisdiction clauses. So the work that they were doing in relation to the contracts, insofar as there was any, was governed as between themselves and Privinvest by English law and English jurisdiction. But it's now said that by Privinvest that the logistics entities also became parties to clauses governed by Swiss arbitration, and two different types of Swiss arbitration. So one has a veritable web of contractual arrangements and competing and different clauses. And it is important that those factors are properly taken into account. And they were by the judge at first instance, and that's why your lordship, I think Lord Hodge, you rightly identified that he had considered the multiplicity of contracts and parties point and concluded that a narrower approach to a sufficiency of connection had to be taken. And you'll see if you do look at his judgment at 851 of the call bundle, paragraph 97, that in fact his finding was that the potency of the Swiss version of the one-stop shop principle is much attenuated in the situation at hand. And that was what led him to say that one has to construe them with a narrower mindset. Now, as I say, his conclusions on Swiss law were upheld and left standing and unimpeached by the Court of Appeals. That's 75 to 78 of the Court of Appeal judgment. And it's important, though, because if you do the analysis we say needs to be done but wasn't, you can't approach it with, if I can call it, the Fiona Trust goggles on. Because, tempting as it is, and my learned friends have sidled up to the notion of saying that the judge effectively found that Swiss law was like English law in that Fiona Trust mandates a wide and presumptive one-stop shop principle. That is certainly not the proper context in which this case has to be decided. So we do commend the dicta of Lord Justice Morbick in the Dalla case at the Court of Appeal level, which we've cited in our skeleton. It's bundle page 1979, paragraphs 28 to 29, where he recognised that one has to, in a case like this, have due deference to the judge who heard the experts giving their evidence about Swiss law, and in fact engaged in a dialogue with the experts, as Mr. Justice Waxman did, to understand the nuances of Swiss law as they pertain to the contracts in this case. Now, that's all to say that this is a particular reason why the Court of Appeal needed to, if it were to overturn Mr. Justice Waxman's decision, engage in the analysis of what it means for there to be a narrower test of sufficient connection and for the one-stop shop principle to be much attenuated. And it is, in our submission, rather dangerous for an appeal court to consider itself as well placed as the judge who heard that evidence and questioned the experts to come to a different view. And of course, if a judge in this situation normally makes no error of principle, then that evaluation as a degree of sufficiency of connection, which is only has to be said to be realised to be an evaluative question par excellence, is not one that the Court of Appeal should have interfered with at all, and certainly not without analysing all of the complexities that I've just been through. And the other thing your lordships might note is that the concept in Swiss law that a claim or dispute has to have sufficient connection with a contract is an odd concept unless you ask yourself the follow-up question, which is sufficient for what? Because it's not meaningful in my respectful submission to simply say that connection is sufficient. Of course, the answer is that's sufficient to find yourself in the arbitration clause, but that just begs the question. And the answer has to be, as a matter of construction, are the connections that are identified sufficient for the parties to be presumed, as a matter of Swiss law, objectively to have intended in good faith that claim be arbitrated and only arbitrated within the clause? But again, one finds none of that questioning of what sufficiency of connection actually means in the Court of Appeal's decision. And if you don't analyse that, you equally don't ask, and it's important we say that one does ask, how each relevant matter that is identified is connected to each supply contract, both as a matter of law or evidence, perhaps, if that's relevant, why that connection is sufficient to draw a conclusion as to the party's objective intention, and why, in particular, you're looking at the party, which parties in particular you're looking at to discern their intention. Because you can only use D6 as intention to discern the scope of the pro indicus arbitration agreement in the supply contract. You can't look at what D8 or D7 or D9 or D10 had in mind. Now, one aspect in which the Court of Appeal failed to engage meaningfully with this analysis is in actually looking at the wording of the arbitration agreements, which one normally regards as the starting point and sometimes as the ending point of the debate. But we're in a world, as I say, where the one-stop shop principle has been found to be much attenuated by the judge, and a narrower approach to sufficiency is appropriate. But if one doesn't therefore apply that for the wording and the context of the clauses, one isn't doing the necessary work. Now, the supply contracts, in fact, we say, as the judge said, have clear indicators that the arbitration agreements within them are intended by the parties to cover disputes confined to the particular subject matter of those contracts in a rather technical way, in some way, namely disputes as to the supply of the goods and services stipulated under them. And as the judge found, there is, we say, an clear intention that claims in respect of things like bribery and conspiracy that one might describe as arising above and across all of the contracts and none of them at the same time, involving the joint liability of not only the contracting parties to each of the supply contracts inter se, but also Credit Suisse and the individual defendants and the Mozambican officials. All of that, my lords, is to say that it's clear in our submission, as it was to Mr. Justice Waxman, that they were not intended to cover the sorts of bribery and conspiracy claims now advanced that have to which the supply contracts have no legal relevance. Now, the supply contracts in this case achieved that, we say, in two different ways, and it's notable that there appears to be a degree of symmetry to this. All the clauses you'll be able to see from the Court of Appeal judgment in one place is probably the easiest to see. If one goes to 766 of the core bundle, it's paragraph 1113 of the Court of Appeal's judgment. And I do say that it's important to look at this, because although the Court of Appeal recited them, the court singularly failed thereafter to take into account some important aspects of them.
Sorry, reference again?
Yes, paragraph 11, my lord, on page 766 of the core, of the electronic and...
128.
I'm sorry, you're there before me, thank you, 128 of the hard copy. There you have set out, first of all, the identical provisions in pro indicus and in martyrdom supply contracts. That's at paragraph 12. And the point here, my lords, is that it's not in the normal form of disputes arising in connection with a contract. In those contracts, the parties chose to define disputes by reference to connection with a project with a capital P. And you see, they provide for ICC arbitration in Switzerland, in Geneva. And you'll see from paragraph 11, actually, of the Court of Appeal judgment, that those two contracts, as you would expect, went on to define the defined term project with a capital P by specific reference to the assets and services also defined in a technical sense. That's to say the goods and the things and the services that were being offered. And the Court of Appeal rightly also notes, and I'll show you this separately perhaps, in paragraph 11, that each supply contract also specifically limited the obligations of the Privinvest party, D6, D7 or D8, so that they were owed solely to the customer, that's the SPV, and not to any other person. I mention that because it's relevant, of course, when considering civil law concepts in particular of delict, that it's not wrong to say that delictual obligations are owed by one party to another. these clauses specifically provided that no delictual or no contractual or delictual obligations, we would say, were owed at all to anybody apart from the contracting party, the SPV. Now, so the first way in which we say that one has to look at the pro indicus and Imatum contracts in their particular form is to look at the definition of project and to realise that that's not the same as saying contract.
Where is the definition of project?
Can I show you, Lordship, from, it's not set out in the judgment, so I'll have to take you to page 1532 of the electronic version. 1532. And you'll see there, they are defined, as I've said, in a technical sense. They simply list the assets and services laid down in a technical project description, and then define separately the assets and the services. Well, that's quite a clear, we submit, indication that the connection one is looking for in this arbitration clause isn't with the contract in a generic way, it's with the project. And that certainly makes it rather different from a Fiona Trust-style English standard wording clause. Now, what's notable, if I may say, is that the MAM contract takes a different view, but we say achieves the same result. And it may... one simply doesn't know how and why these were drafted. But this is quite important. Can I ask you to turn back to the Court of Appeal's decision at paragraph 13, please? Because that's where it's set out most conveniently, perhaps, alongside the others. This time, as you see from the first quoted paragraph in paragraph 13, the definition for the dispute part of the arbitration clause is indeed by reference to claims and controversies and disputes arising out of or in relation to the contract in the standard form way, but obviously it provides for Sky the Swiss rules of arbitration, not the ICC rules. And as I've said, one has to approach that wording not with English law goggles on, but through the nuanced, attenuated way the judge describes it. But it's the wording that's quoted in the second paragraph underneath that's important, and actually really rather important in my submission, and is both quoted by the Court of Appeal but ignored thereafter, and is ignored by my learned friends. And this is that the customer, and that's to say the SPV in this contract, the MAM contract, hereby expressly acknowledges and agrees that this contract is independent from and not accessory, collateral, or otherwise connected with any other contract which the contractor, that's to say Privinvest D8, or any party connected with the contractor, that obviously covers D6 and D7, as well as D9 and D10, has entered into with anyone affiliated to or connected with the customer. And that includes, therefore, the Republic and the other SPVs. That
Law finding has the significance of that.
Not a finding as the significance mode, no. There's no suggestion that it doesn't mean what it says. In other words, that the parties, there's no special construction approach one takes to that. It is, though, it's important to stress, part of the clause that's described as the dispute resolution clause. It's not a separate clause. But your Lordships, I hope, will see the point immediately that the parties to the MAM arrangement, that's on the assumption that it's the Republic, also D8 and D10, but not D6, D7, or D9, those parties have expressly agreed that this contract is not connected with pro indicus or Imatum. And in that context, when my learned friend has to prove on the balance of probabilities that bribes paid, that the claim of bribery against D8, who is the party to the MAM contract, in respect of the pro indicus or Imatum transactions, are sufficiently connected to the MAM contract to fall within the arbitration clause against D8, one sees that this is effectively a block, because the parties, D8 explicitly has agreed that there is no connection between this contract and the earlier contracts. Now, the rationalisation may be that this was the way to achieve what they'd achieved by defining the dispute resolution clause by a definition of a project in the other two. But it doesn't really matter because this one is clear. And no analysis of this question, the ultimate question on this application, which is the sufficiency of a connection to the MAM arbitration agreement, could possibly be undertaken without taking this express agreement into account. And
So the second paragraph in paragraph 13, was that part of the arbitration clause?
it was part of the same clause headed arbitration, I think. I can tell you where you can find the...
So you're saying that when you read any dispute arising out of in relation to this contract, you've got to read that together with the second part of the clause?
Yes.
Which tells you that it doesn't include anything connected with any other contract.
Yes. In fact, it says it in terms, my lord. And so within the same clause, you have disputes in connection with this contract and an
But
explicit...
it's in relation to, but it comes to the same thing.
I'm so sorry, you're quite right.
Yeah.
In the same clause, you have, by the way, this contract is not connected to the other ones, which is obviously a reference to the early ones. So, posit a claim against D8, let's say in conspiracy, which we bring. In respect of the loss we claim to the Republic flowing from the Pro Indicus guarantee, the first transaction, or even the Martin guarantee, doesn't matter. How can there conceivably have been an agreement with D8 that there is a sufficient connection between those claims and this contract? And there is an express, we say, eschewing of that connection, let alone a sufficient connection, even before one begins to analyse the nuances of the narrower approach and the attenuated effect of the one-stop principle. It's also relevant in my submission in telling that all of the contracts included the clause that you'll see partially quoted in paragraph 11 of the Court of Appeal's decision, which says that, you'll see that in the original, let's take the Pro Indicus contract, clause Q, page 1540, and it says all or any obligations of the contractor, that's D6, D7 or D8 in each case, are owed solely to the customer, the relevant SPV, and not to any other person or entity, including, and this isn't quoted in the Court of Appeal judgment, but it says including but not limited to any person providing finance for or in relation to the project. It's quite an important part of the provision that's not quoted by the Court of Appeal.
And the reference again, please.
1540.
Thank you.
Now, of course, on any sensible analysis, the Republic is a party providing finance for or in relation to the project, because it and Credit Suisse are the parties to the facility agreement. Sorry, it and Credit Suisse are parties to the guarantee, and the guarantee supports the facility agreement. But there is an express disavowal in each of these contracts that Privinvest, the D7, D6, D7, D8 entity, owes any obligation to the Republic or anybody else, particularly in relation to financing. And as we say, taken in a contract governed by a civil law system, that is perfectly apt language to exclude any liability in tort or any obligation in tort under a delictual analysis. But that is simply not grappled with. Now, there is a problem that arises here, because the assumption your lordships have to operate under is absolutely silent as to what rights and obligations the Republic became party to, or entitled to, subject to, if it did become a party. The only case that there is at the moment, as far as we can see by Privinvest, is that by operation of Swiss law, the Republic became a party to the arbitration agreement. Now, conceptually, that's possible. But it's rather important, it doesn't appear to be said in the defence, for example, that the Republic owed any obligations or breached any duties under the contract. It's quite carefully worded to avoid saying that in some places. But it does raise a rather difficult question, which is how does one well, let me start again. It may be the case that the Republic is only a party to the arbitration agreement, in which case one can construe that in that context. But if it's going to be said, and it's not clear whether it will or not, that the Republic was in fact standing in the shoes of the customer, because it was effectively one and the same party, it was the SPV, it was for its benefit that this contract was entered into, and much as it would under the 99 Act in this jurisdiction, the Republic was able to, became subject to or entitled to the rights under the contract as well. One would need to know that, really, to work out whether the clause had any different effect in terms of what it's getting at. I don't think there's any way around that for present purposes. One has to simply assume at the moment that the Republic is simply going to be said to be a party to the arbitration agreements. But it's simply not clear, and that's another unsatisfactory element of the Privinvest case. But anyway, taking that...
Since you're not claiming any rights under the agreement, really matter, does it?
Not really, my lord, but it might matter if one was... If you don't know what the rights and obligations are of the parties, it's quite difficult to understand what the disputes
There could be.
Yes. And also...
maybe there couldn't be one.
Yes, maybe. But it's quite a big question also if you're trying to say that your claim should have been brought under the supply contracts, or your claim is for rescission of the supply contracts. Because if the truth is we're only party to the arbitration agreement, we might not have a right to rescind. We might have no rights to enforce. And if that's the case, then the entire premise of my learned friend's case falls away. So that's a rather difficult and unsatisfactory element of the way the case has proceeded on the Privinvest side. But in any event, when you've got an express disavowal of any obligations being owed by the Privinvest entity to any other party, including those providing finance, which on its face we say covers the Republic, certainly, how can, say, the parties to the Pro Indicus supply contract sensibly be taken under Swiss law to have intended a tort claim brought by the Republic for loss caused under the guarantee to be caught by the clause, even in relation to the Pro Indicus contract itself, the transaction itself, let alone liability arising under the Martum and MAM guarantees. So those, my lords, are a few examples, we say, of how any analysis of sufficiency of connection has to work through the issues created by the different parties to the contracts, the varying degrees of relevance or connection, if any, between the claims made in respect to the Republic's liability as guarantor in one transaction, say Pro Indicus, and the supply contract in another, say MAM. And, of course, it says nothing about the restitutionary type claims, which in English law have absolutely no connection to any contract whatsoever. Unfortunately, the Court of Appeal don't say anything about any of those matters.
I suppose if you were party to the arbitration agreement but didn't have any rights or obligations under the contract, still might bring in a claim for inducing a breach of contract or something like that against you.
In theory, it's possible, isn't it, my lord? Yes, but it's also possible that it's useful to bind you into some resolution process. It's not a wholly pointless exercise. My submission would be that it's, without identifying what the rights and obligations are otherwise, one is left in something of a vacuum. But these pointers, if I can call them that, that's to say the exact terms of the arbitration agreements and the express disavowal of obligations to third parties, apply in any event. They subsume that point. They, in our respectful submission, cry out for a proper analysis of how, in those circumstances, each clause can apply to each party in these proceedings, and each claim in respect. There are temporal issues that also need to be grappled with, of course, which haven't been, because the supply contracts and their relevant arbitration agreements only came into existence in the order and in the timings that I've identified at the beginning. January 2013, and then August 2013, and then May 2014. So if you claim, as we do, in bribery against D7, D8 and D10, for the loss flowing from any liability under the Pro Indicus contract, the first one, the Pro Indicus guarantee, well, there weren't any supply contracts in existence at that point between anybody and D7 or D8, and there weren't any subcontracts in existence with D10. But our cause of action must have accrued clearly at the point at which the Pro Indicus contract was entered into at the latest. And so one has to ask, well, how was it intended by parties to the later MAM arbitration agreement, 18 months later, when they came to agree what they agreed in the form of the words I just showed you, that that clause would cover liability in respect of bribery that had happened 18 months ago in respect of a totally different contract? You'd have to have some indication, surely, in the MAM contract that the parties intended it to capture pre-contract liability in relation to other transactions. And yet, in the MAM contract, as I've shown you, you have the very opposite. You have a stipulation that specifically separates and disconnects the contract from what went before. There is a huge analytical hole as a matter of timing and ordering of these contracts. And as I said, the problem doesn't really end there because you've got to fold in the logistics issues. I won't go over that again, but if D10 is indeed the only relevant subcontractor under the MAM supply contract, as it was, how can a claim against D10 in relation to its liability, if it was a party to the MAM supply contract, causing loss in relation to the Pro Indicus and De Martin transactions, fall within the MAM arbitration agreement? It's got all the same problems and more as for the other claims and the other parties. I have mentioned that those subcontracts are governed by English law with exclusive English jurisdiction clauses, which is a factor the judge did take into account and was held to be he was entitled to, obviously. One might, I suppose, sum it up in this way. Let us assume on the facts that no part of the MAM transaction, the last one, can in fact be impugned or can't be tainted with bribery, because on the evidence as it appears at trial, it turns out that the relevant people acting for the Republic at that point were not corrupt. None of the relevant people were corrupt in MAM. There'd be no claim in connection with the MAM supply contract at all. But how then could the claim against D8, who is a party to the MAM contract, possibly arise under the MAM contract? But D8 is alleged to have been liable in bribery for causing the loss under the Pro Indicus and the Martin contract. Now, standing back, my lords, from all of that, and really as our conclusion in relation to the first ground of appeal, the error, we say, with all respect, in the Court of Appeal's approach was fundamentally the omission of any of the analytical reasoning on what the sufficiency of connection means for the purposes of this exercise by applying Swiss law in its form as nuanced and correctly held by the judge, and asking whether and why it was satisfied in relation to each party, each claim, and each contract. And we do say, standing back, the judge was clearly right to say, well, what were rational parties in the position of a nation-state like the Republic of Mozambique on one hand, and contractors supplying goods and services to its SPVs on the other? What must they be assumed to have intended would be the appropriate forum for the litigation of a complex international fraud case involving the major international banks in the who were involved in the financing, the corruption of its public officials on a grand scale? Can they really have been intended, with these clauses in those words, in the context in which they were agreed, to have intended that that dispute would be fragmented into at least 3 separate arbitrations, one under each supply contract, and of course in English court proceedings, because that's what the banks had contracted for, and into different fora within the arbitrations, including 2 different incompatible arbitration rules? Now, the suggestion from the other side is, well, what you're doing is praying in aid fragmentation. And that is not something that overrides the sanctity of contract when it comes to the enforcement of arbitration agreements. But with respect, that puts the cart before the horse, because it may be that fragmentation has to follow if that's what the contracts provide. But the first question is, do the contracts provide it? when construed under Swiss law, with the nuances the judge found, and with the wordings of the clauses that I've just identified. And as part of that process, it is legitimate, and the judge was right to say, you can take into account the fact that a claim of this nature, and of this scale and of this number of defendants, and across and above all of the contracts, one can assume properly and genuinely that the parties must not have been taken in good faith, have intended that to fall separately into each contract arbitration clause.
I suppose the one-stop shop principle is a form of imputed intention to what reasonable business people would intend, and if it's not going to be a one-stop but a 10-stop shop, then maybe you don't infer that that's what they intended.
Yes, and I think that's essentially, if I may say, my lord, the driving factor behind the judge's decision, and we say obviously right. Now, of course, one has the added problem here that the parties were different in some ways to each contract, but of course the parties were also common on the Privinvest case, because they say the Republic was party to some and the logistics entities were party to all. There is at least commonality as between Republic and logistics entities. But the point is, no one is saying that in fact there wasn't a relationship between the contracts. As a matter of fact, clearly one followed the other, and there was some evidence, I think, that there were more than one was intended at the beginning. That's not the point. The real point is, as your lordship says, that the directing minds, the common directing minds behind these parties cannot seriously have intended that this would be the outcome. And there ended up being, if I can just fill in the facts, there were in fact 5 arbitrations started by the Privinvest entities, I think, in each case. 3 in the ICC, under the ICC clauses, 2 under the Sky clauses. The ICC ones were consolidated. The Sky ones were not. They had the same tribunal, and they started being managed together, but they also ended up some of them ended up being out of sync because of failures to pay security ordered in each arbitration at different stages. And the upshot is, as I think you've seen, that they're all now defunct, and there are no arbitrations because security wasn't paid, and that's the end of it. And that's not technically relevant to the Section 9 point, because you don't have to have an extant arbitration to come under Section 9. But it rather shows the faintly ludicrous prospect of commercial businessmen. And I may say, we're not in the realms entirely of commercial businessmen here. We're in the realms of a nation-state wanting to have justice for its corruption of its officials on one side. But the idea that they intended in using the clauses of this wording to achieve that outcome is, we say, unsustainable. And the judge was right. Now, in the time available before I finish today, I'd like just to say a little bit about the second ground of appeal.
Just before you do, yes. These 5 arbitrations, all of which have been discontinued, they were started at the instance of the Privinvest parties against
the Republic and the SPVs in all cases, I think, on the basis they were saying, as they say now, that the Republic is party, and that was going to be obviously one of the issues in those arbitrations, as to the jurisdiction of the arbitrators over the Republic.
And the fact that they were discontinued doesn't mean that they couldn't reapply for a fresh arbitration?
I think they were dismissed without prejudice in that
Dismissed
sense.
without prejudice.
But they are no longer on foot, is the upshot. And there were 5 of them. And of course, what happened, there were various different permutations, because the logistics entities started arbitrations later, when it was realised they might argue they were parties to them as well, one assumes. And that's why there were 5. And in fact, I'm told I was in error. It was the 2 Sky arbitrations that were consolidated. The ICC refused to consolidate the 3 that were started under its rules. It doesn't matter, but that's just a fact.
But they were saying the Republic was party to the supply contracts.
They were, yes. And that was resisted, obviously.
And what were they claiming? Declarations they were valid contracts or something like that? Or
I believe so, my lord. I wasn't close to the arbitration, no. But that's essentially, as you'd expect, a declaration
They weren't claiming more money under them. They probably had
No,
that.
there were monetary claims, of rather sizable nature made.
Right.
Anyway, so ground two really addresses, and one could take this shortly, it really addresses what is a matter, or more particularly, I suppose, what is a matter in respect of which proceedings are brought for the purposes of Section 9. Because one is asking there, not, we say, whether there is an issue in the claim or one raised by the defence as just a pure issue, a dispute, a matter that the parties don't agree about. One is asking, for the first stage of Section 9, what is the matter in respect of which the proceedings are actually brought? And that is a subtly but importantly different question. And the starting point, again, and this is why there's overlap, is that an issue raised or intimated by way of a defence could only be a matter, and it could only conceivably render a claim a matter for the purpose of Section 9 if the defence was capable in law of amounting to a defence. We've been over that ground, and I won't repeat it. But it arises in ground 2 to that extent. Now, there is a degree here, as I said earlier, of agreement between the parties, because we say that the law, certainly until Ruhan, was fairly clear that matters include those things on the critical path to establishing liability or disproving liability. A sort of critical path, essential element approach is taken. And we set out some of the cases that support that proposition in paragraph 136.1.3 of our case at page 92. And it's long been recognised that the fact that as a result of proceedings there is a dispute between the parties about a matter that may be referred to arbitration doesn't mean that the proceedings are in respect of that matter. That's regarded in, we say, as something of a truism in cases, and we cite in particular the Lombard case, which is one of Mr. Justice Andrew Smith's, at paragraph 19 of his decision at page 2647 D to E. But in a sense, my lords, that proposition ought to be self-evident as a matter of principle, and it does appear to be accepted by the respondents. So could I just show you perhaps their case at page, para 49, page 115 of the electronic bundle, and page 94 of the hard copy. There the defendants say the inquiry is only into those issues which, if made out, would constitute a defence to the claim or cause of action.
Which paragraph, sorry?
It's 49, my lord.
49.
And it's the second line, and it starts the inquiry. Inquiry is only into those issues which may, if made out, would constitute a defence to the claim or cause of action. A defence with no connection to the claim or cause of action is not, in that sense, a reasonably foreseeable one. And then a similar point is made at 150. If I could ask your lordships to look at the bottom of that paragraph 50, the bottom where there's 5 lines from the bottom, it says the distinction. They say the distinction is between, one, an arbitrable defence which, if made out, would constitute a good answer to the claim. This is not subject to review on the merits by the court. In other words, there's no strikeout available if it's legally possible to be a defence. And two, an arbitral defence which, if made out, would not constitute a good answer to the claim. In this situation, it could not be said that legal proceedings have been brought in respect of a matter which is to be referred to arbitration, since the claim brought does not engage the purported defence sought to be raised. And that, we say very much, is the territory we were in when we were looking at the bribery claim in English law. And again, just to pick up the wording that they actually use, if one jumps to 107 of the case, which is 107 sub 3, page 139 of the electronic bundle, 118 of the hard copy, you'll see that the Privinvest respondents do accept in little b.
Sorry, can you just give that reference again?
Yes, my lord. It's paragraph 107 3b, and it's page 118 of the hard copy. they accept that an issue will be a matter, and this is 3 to 4 lines down, by its being an essential element of the claim or an essential element of a defence which wholly or partly defeats the claim, as to liability or quantum or both. Now, the word essential is important in our submission because it is not merely evidential if it is essential. A potential example might be a fact, of course, which is disputed, that would tend to prove or disprove honesty when weighed in the balance with other evidence, or a fact which, if proven, might make it more or less likely that the party would establish its cause of action, and this, or one element of it. This goes back really to what my Lord Legate said earlier. It's not good enough to say it's an evidential matter which will weigh in the balance in that sense, even if it's in dispute. It has to be essential in the sense of legal relevance to making out the claim or defeating it. That's why the suggestion that the validity or whatever of the supply contracts made by the respondents is evidentially relevant to honesty or dishonesty might be one of those sorts of issues. And we say it doesn't get through the first gate because there's no legal relevance possible. But even were it to do so, it would not be an essential element, but merely a matter of evidence. Certainly, the idea that upon raising a matter like the validity of the supply contracts in response to a claim that is otherwise not arbitral under the contract, the defendants would achieve a Section 9 stay of the entire claim because they put in issue their own honesty, and that is connected in some way, they say, to the contract. That would be a most surprising outcome. But it is apparently the one they postulate. I'm not sure whether it's always very helpful to offer examples or analogies, and sometimes they work, sometimes they don't. I'm going to try one example, which is, we say, slightly akin to what's happening here. Imagine, my lords, that a claim is made in court in relation to contract 1, which is said to have been positively alleged to have been tainted by bribery and to have caused loss to the claimant company. It's got no jurisdiction or arbitration clause to worry about. It's just a claim for bribery causing loss in relation to contract 1. And there could, for example, then, in that case, be an issue as to the identity of the agent, the single natural person, let's assume, who negotiated and signed the contract on behalf of the claimant company. It could be the dispute, you could easily have a dispute as to whether Mr. X or Miss Y was the person responsible for the dealings in relation to that contract. Now, if the claimant's case is Mr. X has been bribed, but the claimant admits that Miss Y has not been bribed and is innocent, then the entire issue of the claim under that contract for bribery will turn on the evidential question of whether Mr. X or Miss Y negotiated the deal. One can then imagine that in order to prove or disprove the question of who negotiated the contract, and therefore to go to the ultimate question of whether there was bribery affecting it, the defendant's case is that Miss Y had, at similar times, let's say, the innocent Miss Y had in fact been solely responsible for not only the relevant contract, but 3 or 4 or 5 other contracts, all of which were entered into between the same parties, contracts 2, 3, 4, and 5. And the defendant would then rely on proving that as an aspect of proving that Miss Y therefore did sign the first contract and it wasn't tainted by bribery. It would raise a clear and important and possibly decisive evidential question going to the identity of the party that negotiated the contract. C, of course, would disagree, and he says that Mr. X negotiated everything and he was taking bribes all over the place. And therefore, he would have to say all of the contracts that are posited, 2, 3, 4, and 5, were also tainted by Mr. X's bribery. But there's no claim in respect of those contracts. Now, on the defendant's case, if any one or more of contracts 2, 3, 4, and 5 were governed by an arbitration clause, or included an arbitration clause requiring the parties to arbitrate, the fact that an issue relating to those contracts, who concluded them, who negotiated them, Mr. X or Miss Y arose in relation to contract 1 would create both the issue as to who signed those contracts, who negotiated the other ones, make that a matter in respect of which the proceedings are brought, and would drag the whole claim under contract 1 into the arbitration. And of course, everything ultimately depends on the width of the arbitration clauses. But even assuming that they were in the widest possible terms, it couldn't possibly be said in a case like that the potentially decisive factor of who signed the contract, to which all of these other contracts go, was nonetheless the matter in respect of which proceedings are brought under contract 1. It's a matter of language, it simply doesn't work. Now that may be all to say, I suppose, my lords, that what is arbitral in one context might not be in another, and it rather depends on whether they're essential or evidential, or something even less relevant. But what is perhaps important to identify is there is a dispute between us as to, apparently, as to whether something can even be in dispute if it's merely peripheral or tangentially relevant or connected to the dispute. And can I just show you what I mean by that? It's a sort of small point, but it's a perplexing one on the part of the Privinvest defendants, we say. If you look, for example, at their case at 1073A now, and this goes to the question of what Mr. Justice Popperwell was deciding in Ruhan. When he referred, they say, to any and all issues, Mr. Justice Popperwell meant any and all relevant issues. An issue will not be relevant, they say, to a dispute if it is merely peripheral or tangentially connected to the dispute. Put another way, such an issue will not be an issue in dispute. Now, we do have some difficulty with that concept, because in the example I've postulated, and in many examples, one can certainly have a peripheral issue over which the parties are in dispute, but which is not, and it's certainly relevant. And so, again, if you go forward to 136.3.1 of our case, backwards to 136.3.1 of our case on page 92, you'll see some examples that are actually in this particular case. I'm sorry, it's 92 of the electronic version, which is '70 of the hard copy. I'm sorry, 71. There are lots of issues, evidential issues in this case, that are relevant potentially and in dispute, but which could not possibly be said to be matters in respect of which these proceedings are brought, that would fall within an arbitration clause. And we set out a couple here. It's pleaded, for example, in the Privinvest defence, that it is common practice when doing business with governments in general and in developed markets in particular, including the Republic of Mozambique, for a foreign investor or contractor to engage consultants to assist in navigating local bureaucracy, or that's para 283 of the defence, or that the contractor or subvention fees were a common market practice endorsed by Credit Suisse and used by the Republic. Now, they are issues, and they're likely to be, I think, in dispute. But if you take the Mr. Justice Popperwell approach literally in Ruhan, they would be issues which, if arbitral, arising in connection with an arbitration agreement, would have to be arbitrated, no matter how peripheral or tangential they are to the real substance of the legal issues in the case. And that's why ultimately we submit that Mr. Justice Popperwell, if he intended to mean any and all issues, to include any and all issues, no matter how peripheral or tangential, or regardless of the substance and regardless of the context in which it arises, then that can't be a correct statement of the law. And we've suggested that it may not be, because the judge might well have had something slightly more nuanced in mind. But my learned friends can't be right to say that there is only an issue is relevant to proceedings, if it's, let me start again, that an issue in proceedings can't be relevant, can't be in dispute if it's tangential or peripheral. Of course it can be in dispute. So they have to read down Ruhan as sort of qualifying any and all issues, as excluding peripheral issues because they aren't actually issues.
So you say it has to be a critical path issue?
It has to be a substantial issue or an essential issue, most commonly on the critical path, but every case depends on its facts in some way. It's quite difficult to prescribe in every case.
I thought that's exactly what the respondents say in their case in 1073A. An issue will not be relevant if it's merely peripheral. I'm just not sure what the disagreement between you is on this.
Well, I think, my Lord, respect, what they're saying is there can't be an issue because you can't dispute something that's peripheral.
I mean,
It's the final sentence of 3A on page 118.
It's the final sentence that causes the difficulty, because there can be a dispute, but so what?
Yes.
As far as the Section 9 stay is concerned.
Yes. It's an oddity. I can't explain it, but maybe Mr. Matthews will. But clearly you can have a dispute of that nature.
no, the previous sentence seems to say just that.
Well, maybe I've made too much of the apparent conflict. Maybe there is.
Will no doubt.
Exactly.
There's some subtlety there.
So, and we do say that if you stand back and think about the approach in Ruhan, any and all issues is clearly too wide if it does mean any matter that is in issue, that is capable of being arbitrated under a clause. Because you have to find that the proceedings are brought, quotes, in respect of that issue. And it's an abuse of language in many ways to say that evidential issues of the kind we say the validity of the supply contract is at most, or my example about the identity of the negotiator of the contract, or the 2 points that are pleaded against us in defence on this. It's an abuse of language to say that the proceedings are brought in respect of those issues. They're simply not.
So that's the point you've made about 3B, isn't it?
Well, I don't have it in front of me again, my Lord.
You emphasised it to us where the respondents say that it may be satisfied by its being an essential element
Yes.
of the claim or an essential element of a defence. And as you said, that would not extend to a purely evidential matter.
Yes. So in summary, my Lord, the vice of the Court of Appeal's decision, we say with respect on ground 2, is that it elides the distinction between issues in the case, that is, the issues, the determination of which are essential, legally or factually, to the claim or defence, and on the other hand, facts and evidence, which might, if proven, have some degree of probative value but might not. We say the latter can't be anything but peripheral and insubstantial or tangential. And in any event, you could never say in almost every case, any case I should say, that those sorts of tangential evidential issues were the matters in respect of which the proceedings are brought.
What do you say about the Tomalugan formula then? Yeah, it's put there.
Well, my Lord, in a sense, that is closer to what we say is...
It is close. I was wondering whether there's any refinement of it or...
I don't have a refinement of it, my Lord. It's just not compatible with what Justice Popperwell appears to have said. There is a tension between that and
We're asked to read into Mr. Justice Popperwell some material in order to reconcile him with Chief Justice Menon in Tomalugan.
Yes.
But there may be a danger here that what the Chief Justice said in Tomalugan, which is just judicial dicta, is beginning to be treated as statute.
Yes, and that's in a way that's because, if I may respectfully suggest, Section 9 is extraordinarily difficult to apply in a methodological way because of the formulation of it. And it involves this sort of, there is an iterative process in my respectful submission where one has to posit what the matters are in respect of which the proceedings are brought, see if you can sensibly apply them to the arbitration clause, to ask the second question, is it required to be referred to arbitration? If you can't, you have to go back and sort of reiterate the matter, the definition of the matter, to make sure that you're looking at it at the right level, either high or low, or granular or not. And it's only by that process that one gets to the stage of being able to say, well, this is the matter in respect of which these proceedings are brought, and I can say it's in or out of the arbitration clause. I'm not sure there's an easier way to describe it than that, and therefore I don't have an improvement to suggest on Tomalugan in terms. But what it is not, my lord, is a search for any issue between the parties that is potentially relevant, that would on its own, in some different universe, be arbitral. And that is essentially, we say, the approach the Court of Appeal took at the Privinvest invitation. Because that's the only explanation, really, for how it captures an issue like the validity of the supply contracts, which is legally irrelevant, but only arguably evidentially relevant in some way. So unless I can assist the Court further at this stage, I've reserved to myself an hour for the reply tomorrow, which is as agreed with Mr. Matthews. I hope that's satisfactory. But obviously, if your lordships have any other questions, I'll answer them now.
If part of your claim is for, in the event that the guarantees are upheld, is for damages in respect of having to pay out under the guarantee,
Yes.
then in that context, the issue of whether or not the supply contracts were commercial would be relevant. But are you saying that's just evidential, or what would the relevance be there?
Well, yes, my lord. This does raise an interesting point, because I think it's fair to say in the first time in their written case of this court, the Privinvest defendants have said that because they argue that credit would have to be given by the Republic for the value of the services, or the use of the goods received under the supply contracts, that makes some kind of difference to the analysis. And they make the point in a number of places. It's a good point. It was never raised in the Court of Appeal, not mentioned, and it didn't feature in the Court of Appeal's judgment as a result. And we would say that essentially this is a matter of evidence par excellence. It goes to quantum, and whether, if you like, they can bring into an account an amount that goes to diminish our prima facie loss, which would be the liability under the guarantees. Now, I leave to one side that there is a rather large legal debate as to whether that's even legally possible, whether there are collateral benefits, whether it's res inter alias acta, and there is going to be that debate at trial, because, of course, the benefits were received and the property is owned in the first instance, and certainly under the contracts, by the SPVs, not by the Republic.
But who owns the SPVs?
They're owned fundamentally by the Republic.
So they've got the benefit indirectly, if not directly.
Well, there's a big issue about that, Manuel. I don't want to venture into it. It's rather an important point of separate corporate legal personality.
Not really. I mean, if a benefit comes to a company, then the net value of that benefit is an asset of the shareholder.
Well, if it has to be analysed in that way, then maybe it will have to be analysed in that way. I'm afraid I'm not able to advance the legal argument. All I can tell you, Lordship, it may be assumed against me. It's a dispute, and it's not actually relevant. It's a threshold question, but it doesn't matter for Section 9 purposes.
But even if there were any force in that point, would it not at most lead to an arbitration dealing with the commerciality of the supply agreements and a potential partial stay in respect of the indemnity claim? It wouldn't stop the rest of the proceedings.
No, your lordship's right, and that's the very end point of my argument, and I accept that the very worst that could happen as far as the Republic's concerned is that there would be decided to be, in this case, it wouldn't be the commerciality of the contracts as much as the value of the goods and services supplied under them to the Republic. That would be found to be a matter in respect of which these proceedings were brought by virtue of it being raised as a defence pro tanto by the Privinvest parties, and that would therefore be a matter that could be arbitrated and a stay, pro tanto stay ordered. But that, my lord, is my last line of defence, if you like, and I would urge against that being the sort of easy, satisfactory conclusion, because in a sense what you're doing by assuming that is saying that just because a matter is arbitral in one context, for example, if one was suing under the contract, the fact that a similar issue arises in the context of a bribery claim otherwise unconnected to the supply contract doesn't make that issue itself one that requires to be arbitrated, and still less doesn't drag the whole claim with it. But that, your lordship, I think, in his example, would accept that on that hypothesis. But we would say, my lord, that you also need to bear in mind, with all due respect, that it has no impact whatsoever on the restitution analysis. Yeah. So you'd never get into the realms of staying the restitutionary claim or anything like that on this basis.
Yeah, I mean, my point was precisely that you know, the worst result from your point of view of that would be a stay pro tanto of the indemnity claim.
Yes. Yes, which...
but you say you don't even get there because you say the arbitration clause isn't looking to arbitrate this wider bribery claim.
Yes, and it's a bit like, if I may say, the transactional set-off cases, where one is trying to set off. What the defence is trying to do, if you like, is to bring into the account, diminish the claim against it, the loss claimed against it, which we say is referable to contract A, some sort of credit that arises that is referable to contract B, which are the supply contracts. And the set-off cases show that the fact that that set-off arises in a context which would otherwise have to be arbitrated is not so where it's amounted as a set-off pro tanto against the claim. One might say it's a sort of defence of a kind that is not regarded as needing to be arbitrated in the way it arises in the transactional set-off cases. I suppose much in the way I said earlier that some of the decisions have identified the rationale for set-off cases as being not properly construed as claims in respect of which proceedings are brought. They're just different.
Or you can look at it in terms of the scope of the arbitration clause, one of the ways you do, and say, well, it's one thing to say you can envisage many types of claim in which the parties would expect to have to arbitrate the value of the goods and services supplied.
Yes.
But they don't include a claim where that's just part of the quantification of some loss in an enormous conspiracy of which this is one little part.
Yes, and that, my lord, is right. And that in a sense goes back to the analysis where if you've got a claim that has got 10 elements of 10 essential elements, all of which are not arbitral matters, the introduction by the defendant of one contingent issue that it might be arbitral is not going to render the whole claim arbitral, because can't have been the intention of the parties.
It's not a black hole that sucks in energy from everywhere around it.
That sort of point has been said before, yes, and that's right, my lord. And all the more so, if I may say, because one goes back to the wording of the contracts that I've taken you to, and it's very important not simply to assume that they are in the standard Fiona Trust style. So, yes, at best it's an example, I suppose, of a potentially arbitral matter that is not arbitral in the context in which it's raised here.
So who would be raising it? I think you've rather said it's the respondents who are raising it, but yes. They say it's your obligation to give credit. So is it not you who have to raise it?
No, well,
I would have thought if you say something you have to give credit for, you have to show that it's a credit to give.
Yes, my lord. Imagine if we're liable under the guarantee and we have to pay $2 billion to the bank, prima facie we've established a $2 billion loss.
Have you? When the price, when the other side of the transaction is is the supply contract.
Well, that's then I would submit for the parties raising it to say, well, for all of these reasons, which will include possibly complicated reasons of getting around the collateral benefit and raising inter alia acta principles, you have got to give credit. It's a bit like a mitigation defence. It may not matter, my lord, because what one is searching for is whether you can answer the question, are these proceedings brought in respect of that issue, and does it have to be arbitrated?
Yes.
And whether you frame it as arising from the defence or from the claimant, I don't really suggest matters. But as I say, you're either got to say it's potentially arbitral, but it's not in this context.
Or not yet.
Or not yet. And of course, it may never be, because the court might decide it's irrelevant. Yeah. Or it's tangential or insufficient, or whatever the analysis is, to render it not one of those kinds of issues that becomes arbitral. And the second line of defence, of course, is to say, well, it certainly doesn't render the matters in respect of which these proceedings are actually brought in their entirety arbitral. And I should say, for good measure, I suppose, it does appear to us that the approach that this arbitral style defence somehow infects the claim is contrary to the authority of China Export, the decision of Sir Richard Field that I mentioned earlier. Because, well, let me just say, for the reasons you'll see we've set out in full in our written case at paragraph 70, where we quote his paragraph 60. And he relies on the Panama Canal case. Yes, my lord, that's all I wanted to raise at this point.
Which paragraph of your case did you refer to there, sorry?
I referred, my lord, to paragraph 70.
70.
70, yes. It sets out in full the dictum on which we rely.
Thank you. Mr. Matthews.
Please, my lords, I propose to start by outlining my intended order of presentation on behalf of the respondents, and then go into the detail in that order. In that context, I'm going to start with some brief introductory remarks to weed out some of what we say is the irrelevant material and to identify some of the key relevant points. And then I shall go on next to take ground of appeal 2 first. That is what one might refer to as stage 1 of the Section 9 test. And I address that first because it logically, we say, comes first, and because also it is the only colourable point of law in this appeal. I then propose to turn to deal with ground of appeal 1, which is essentially concerned with stage 2 of the Section 9 test. The reality, we say, is that there is no significant principle of English law engaged on this appeal. In order to fashion one, the Republic has had to distort and misrepresent what the Court of Appeals said and did in its judgment, and the test that it in fact applied. The true complaint of the Republic is that it does not like the way in which the Court of Appeal has applied the law to the facts, and we respectfully submit that there is no fair complaint in relation to that either. Turning to the introductory remarks, which I shall return to as necessary to develop in context. First of all, the context being Section 9 of the Arbitration Act. This, I appreciate, is a point that your lordships will no doubt be very familiar with and well aware of. That is the context of any Section 9 application. The application which has given rise to this appeal is based on the premise that the Republic has brought proceedings in this court against the respondents in relation to matters which it has agreed to arbitrate against the respondents pursuant to the arbitration agreements contained in the supply contracts to which the Republic is party. The key feature of Section 9 is that, as one would expect of an arbitration-friendly jurisdiction such as this, the legislation recognises party autonomy. A party has the right to choose and agree that it will arbitrate, but therefore also that it will not litigate the matters within the scope of the arbitration agreement. And the respondents simply wish to hold the Republic to its contractual promise to arbitrate and not to litigate the claims against the respondents. The obligation not to litigate is a reflection of the negative element of the arbitration agreement referred to by Lord Mance in the judgment of the Supreme Court in AES Ust-Kamenogorsk, paragraph 1, which you have in your electronic bundle at tab 17, beginning at page 1698, and paragraph 1 of that is at 1702. I don't intend to turn that up because it's also eloquently expressed by Lord Justice Mayles, who gave leave in this case to appeal to the Court of Appeal from the decision of Mr. Justice Waxman, and he expressed it in paragraph 73 of Bridge House, which is in your bundle at tab 22, page 1896.
You needn't tell us tab numbers because we don't have tabs. We are completely electronic, I'm afraid. So it's just to save you the bother.
I'm very grateful, my lord. Thank you. So 1896 of the electronic bundle, paragraph 73. In considering whether a dispute is arbitrable, the fact that the parties have agreed that it should be arbitrated is an important starting point. What that means is that they have agreed not only that it should be arbitrated, but also that it should not be decided by a court. The law permits commercial parties to choose arbitration and should respect their choice unless there are compelling reasons not to do so. Where parties agree to arbitrate, it is the policy of the law that they should be held to their bargain. Lord Justice Phillips endorsed that view to similar effect at paragraph 81 at page 1897 of the electronic bundle. The court points out that there are very few active public policy restraints on that party autonomy. Now, several are urged on your lordships by the Republic in this case, but they do not, in our submission, constitute good reason to restrict the application of the mandatory provisions of Section 9 to enforce a party's agreement to arbitrate and not to litigate certain disputes. The similar approach was adopted by Lord Justice Newey in the same case of Bridge House when he was considering the Fulham Football Club case and the Tomalugan and the Whelans case. And he considers the position first from paragraphs 28 to 31 at page 1884 of your bundle, where he sets out the relevant provisions, and the court was there concerned with the question of whether public policy considerations should somehow impact upon the reading or application of Section 9, and Lord Justice Newey, reciting the relevant provisions at 28 to 31 and again at 42 to 54, beginning at page 1886, where his lordship considers this in the context of the Fulham Football Club case and the Tomalugan case, which of course both involve questions of winding up of companies, impact on third parties and so on, and also in the Whelans case. And finally, he analyses it at 55 to 65, beginning at page 1892. And what we say emerges from that is that the court will only approach with great caution the idea that public policy considerations should somehow impact upon the construction and application of Section 9.
This is concerned with arbitrability, isn't it?
It is, but it's also addressing the question of the application of Section 9. And I'll come on also in the context of this to address another aspect which has been sort of prayed in aid before your lordships. Because ultimately the guiding principle is party autonomy and holding parties to the bargain they have struck. Section 9 is public policy in that regard, and very strong consideration has to be given to that as the starting point. And you do not, therefore, start to read down clauses because Section 9 is going to apply to them. On the contrary, you allow the full effect of the clauses to be given effect by reason of Section 9. And this is going to be particularly so in the context of a case such as this, where the wording of the arbitration clause is in broad terms. Your lordships have seen that in the Court of Appeal judgment at paragraphs 12 to 13, and we develop the matter in a little bit more detail in our case at paragraphs 97 to 102. This is in effect, and I'll come back to it in more detail, in the context of the second stage of the analysis, that this is to answer the suggestion on the part of the Republic that for some reason, because of the wording of this clause, but also the peculiar circumstances of themselves as a republic, the peculiar circumstances of the nature of this type of claim, that one should somehow read down the scope and applicability of the clause. And we say that's not the right approach in relation to it. But I'll come back to that in more detail in the context of the stage 2 of the analysis. But the attempt, we say, to read the clauses in a narrow way by reason of, for example, their reference to project assets and services and so on, simply doesn't bear analysis when one realizes the definitions of projects, assets and services, which in effect comes to the same thing as a reference to, at least as wide as a reference to the contract itself. If anything, it may be wider if one bears in mind the scope and extent of the project involved in this case. And I'll come back to that in the context of the extent to which this is or is not a package. But in any event, we say that the claims brought by the Republic and the Privinvest defendants' defences do arise in connection with the assets and services contracted to be supplied, and therefore, in those circumstances, we come neatly within the clause. The second introductory point I want to focus on is whether there was, or the extensive assertion and somehow reliance upon it by the Republic, that there was wrongdoing in the context of the transactions. Now, this is where the issues arise between the parties, and they are very much in dispute in these proceedings. I'll come back to it in more detail in relation to the various heads of claim. But suffice to say for now, the Republic points out that it is one of the poorest countries in the world and asserts that its officials were bribed to enter into supply transactions for the supply of equipment which were not in its interests, and from which, they say, it received very little in value. That is the substance of the claim, and I'll come back to show that is the way it's advanced against my clients, and that is going to be the central element of the matter when it is addressed in the autumn of this year. I'll come back also to how that comes about in the circumstances. It is not, however, relevant to this appeal that that is the nature of the claim, or that they are, whether one of the poorest countries one of the richest countries or not a country at all. None of that impacts upon any issue arising on the Section 9. Save, however, of course, that the fact that it is presented in that way by the Republic is something of a pointer to what are the real matters in dispute in these proceedings. But as your Lordships will appreciate, my client's position is that the transactions were not the subject of corrupt payments. The current President Newsy was at the material time Defence Minister and centrally involved in the negotiation of the transactions. He was directly and indirectly in receipt of payments in relation to them, mostly by way of campaign contributions, and we were led to believe that there was nothing reprehensible in the context of Mozambican law in the context of this, and this is why, and I'll come back to it, the issue of Mozambican law also rings strongly in this context. Now, what has happened in these proceedings is we say they are the product of a political volte-face on the part of the now President, but the transactions were legitimate transactions concluded by the Republic perfectly properly by reason of their understandably perceived desire to exploit their maritime economic zone by procuring a fishing fleet capability backed by a defence capability to protect that fleet and infrastructure to support those fleets and related software and training. The supply transactions were the route to achieve greater prosperity for Mozambique had they been properly performed by the Republic, and had the equipment supplied been properly used, the Republic would have been enriched. Accordingly, it is my client's case that the supply transactions were very much in the interests of the Republic, but the opportunities and benefits have been squandered. All of that will come into the analysis in the court proceedings, not least on the subject of damages and remedy available to the Republic in the circumstances, but also in the context of whether there was wrongful conduct on the part of my clients and the benefits that, in fact, the Republic procured from these contracts.
Can I understand, the idea of payment of monies to a politician to support his campaign being valid and legitimate, is that dependent on your assertion of Mozambique law? Because I would have thought that it would have the potential to fall within the English law of bribery or secret commission.
It is not, as I understand, well, one of the difficulties is that is not ventilated, because although the President Newsy has been joined as a Part 24th party to these proceedings, he has refused to have anything to do with these proceedings, and so the nature and scope of his payments have not been canvassed, because the Republic itself does not assert the payments in relation to President Newsy. It excludes those from the list of payments that it complains about. So,
but your defence is in relation to payments that are complained about, and I thought you were saying your defence was they were campaign contributions, or some of them were.
I was saying that the payments to or for the benefit of President Newsy were in significant measure contributions.
But they're irrelevant, aren't they?
Yeah, they're not part of the
there's
claim.
no claim in respect of them.
Well, they are and they're not, my lord, for these reasons. We say that we were led to believe that payments of these kinds were permitted in Mozambique and under Mozambican law. And there's also a series of misrepresentation claims in relation to President Newsy, but also by way of attribution going to the Republic itself, in consequence of which we say that the Republic had knowledge of and or was party to the representations as to the permissibility of these payments, and therefore is not able to challenge those payments.
What about Credit Suisse? What were they for? What were those payments for?
That has already been covered, my lord. Those were payments in relation to the development of a joint interest. There weren't payments to Credit Suisse.
No, Credit Suisse employees.
To Credit Suisse employees in relation to the development of a joint business. And there are questions also in relation to that as to whether there was knowledge of it and so forth. But all that we say in this context is that our case is that there were no illegitimate payments. All of the payments were legitimate in support of a project which was put forward by the Republic, which was a project which the then Defence Minister, President Nyusi, and others, including the then President, President Gabuza, wanted these projects to come into existence for the benefit of Mozambique. And the benefits have been accrued, equipment was supplied in very large quantities and very large values, and inevitably, therefore, whereas the Republic is trying to analyse this in terms only of its ultimate exposure, as it were, in relation to the liability under the guarantee, the fact is that all of these contracts were entered into by SPVs owned by the Republic for the benefit of the Republic, with the full knowledge of the Republic, and with the benefit of the Republic intended to be achieved by them. And so, in that context, we say the references to whether the Republic is a rich or a poor country, whether there's alleged to be bribery or not, none of those are relevant considerations for the purposes of this analysis of the operation of Section 9 and whether these claims were required to be brought or not. And again, in this context, the Republic points to plea bargains which certain Credit Suisse employees concluded in criminal proceedings in the United States, but they do not refer to the fact that the managing director of my clients, John Bustani, also in those criminal proceedings in the United States, was acquitted in relation to these matters of any wrongdoing. And that's, it is recited in the paragraph 33 of the amended claim particulars, which you have in your bundle at page 421. And so one doesn't start from the premise that one is dealing with a particular type of claim or a particular type of factual situation which is somehow relevant to the Section 9 analysis. We say it is not. It is the considerations or the construction of Section 9 of the Arbitration Act falls to be the same, whether there are allegations of bribery or of any other tort or breach of contract without the taint which attaches to bribery. And of course, as is well acknowledged by lordships here, such an issue is as arbitrable as any other issue which impugns the contract, and long gone are the days when there were any question marks over whether issues such as fraud or bribery were arbitrable because of the nature of such claims. Obviously, it's recognised that they are. The third point that I wanted to touch on by way of introduction is that the Republic from time to time in its argument seems to make something of the fact that neither it nor D9 and D10 were signatories to the supply contracts containing the arbitration agreements. That is of no significance. Mr. Justice Waxman, having recited the assumption which is to be carried forward not only through his judgment, through the Court of Appeal, but also through these proceedings before your lordships, the assumption that the Republic and D9 and D10 were to be a party to the arbitration agreements, nevertheless went on to say that that could not alter the fact that the claims were made on the basis that the Republic was not a party to the supply contracts. That, we say, is not the correct analysis, and a similar issue has been obliquely raised orally before your lordships this morning, suggesting that somehow the Republic's claims by definition have to be framed in a particular way because they say they are not parties to the arbitration agreement, they're not parties to the supply agreement. That is to beg the question if in fact the position is and is established that they are parties to the arbitration agreements and the supply contracts, well then of course that opens up the other claims through arbitration which they say that they somehow don't have in this context. The Republic doesn't really indicate what relevance it has, but in our submission it has no significance. All that has happened as a matter of case management is that Mr. Justice Waxman decided to bifurcate the issues in Section 9 and to take the scope issue first. And the other matters relating to the Section 9 proceedings were held over, including, in particular, whether and if so how, as a matter of Swiss law, the Republic and D9 and D10 became parties to the arbitration agreements in the supply contracts. That the further event that took place subsequent to that, in answer to a number of the questions from your lordships this morning, is as to what is happening now and whether there's been an application for a stay in relation to the liability issues. There was such a hearing and an application. There was a CMC conducted by Mr. Justice Knowles, and Mr. Justice Knowles decided that there should be no stay of any of the other matters, and therefore what is being tried in the autumn is a unitary trial, not only involving all the parties to these proceedings, but also parties to the other proceedings brought by VTB against the Republic. Those proceedings are at a different stage because in those proceedings, similarly under the relevant guarantee that Credit Suisse was party to in these proceedings, in those proceedings where VTB is the claimant, the Republic has claimed sovereign immunity in relation to the claims, and therefore there are preliminary issues to be resolved in relation to those proceedings. Those preliminary issues, together with all the other issues under these proceedings, are being determined in the autumn. So there was an attempt to stay in relation to the matters affecting my clients, but Mr. Justice Knowles decided not to stay. So that is how we come to be having a full liability hearing in the autumn, and that is how the, in reality, the impact of the hearing before your lordships is relatively limited, because from a practical point of view, my client, the respondents, are going to have to address all of the allegations which we say should properly be the matter of arbitration, and which the Court of Appeal has held should be properly the matter of arbitration, subject to the parties' point. We're going to have to address them nevertheless in the autumn. The position as to the assumption is that your lordships would, I anticipate, continue to operate on the same assumption as operated throughout, namely that the Republic, D9 and D10 are presumed to be parties for the purposes of this appeal. And if we can see it neatly encapsulated at page 928 of the bundle, this is in the Republic's skeleton argument at first instance, and it sets out the assumption in paragraph 23. The proper construction of the arbitration agreement falls to be determined on the basis of facts assumed in favour of the applicants. In summary, and then 23.1 is the position of the Republic, namely that they are bound to the arbitration agreements in the supply agreements, and 23.2, that D9 and D10 are bound to the arbitration agreements in the supply agreements, and the objection is taken in the Republic's pleaded case that the premise is the existence of intercompany agreements, but only 3 such agreements rather than 6 have been produced. That is the basis of the objection, as it were, to the assumption, but what that assumption is quite clear. namely that for the purposes of these proceedings, including this appeal, the assumption is that D9 and D10 are bound to the arbitration agreements in the supply agreements.
In all of them?
In all of them.
Or even the ones they were not subcontractors for.
Yes, the way in which it arises under Swiss law means that that is also possible. Whether it proves on the facts to be correct is a matter that will fall to be determined when the issue of parties is resolved. One of the difficulties, unfortunately, is, and my friend tries to make capital out of it and blame my clients for it. My clients have, as a matter of procedure, opposed the process that has taken place at every stage. So it is a little unfair to blame my clients for where we end up. But the short point is that the issue of who are parties and why has not been fully and properly ventilated and won't yet be. And of course, ultimately, the nature and effect of some of the clauses which you were being invited to look at today in the supply agreements as to stipulations as to whether the obligations are owed only to the contractor or the counterparty and things like that. All of the implications of that and what that means and whether that includes the Republic or not, first of all, haven't arisen yet. Secondly, would arise at the earliest possible stage, but we say not even then, at the parties stage. But there is the reality that the application or construction of these clauses and what that means for the obligations of the parties will ultimately be a matter for the arbitrators under the arbitration agreements, because they are the people whose job it is to construe these clauses and identify what it is that they mean. So as to whether there is an arbitration agreement, clearly that is a matter for the court. As to whether as to that, it's not yet before the court. As to the scope of the arbitration agreement, that is the bit that's been hived off and comes before you today. It is in that sense incomplete, and it may in that sense be unsatisfactory. I cannot take, however, the blame for the fact of where we are today, and obviously we have to proceed on that basis. But
I'm meant to take it from that it's a matter of agreement, that what is set out in 23.1 and 23.2 of the skeleton, including the last sentence of 23.2, as to timing, D9 and D10 became bound to the Perindicus, Amatum and MAM supply agreements on the dates thereof. That's an assumption we are asked to proceed with.
these are the assumptions.
As a matter of agreement.
My Lord, those are the assumptions on which we have been proceeding, as I understand the position.
And you understand both parties are proceeding on this scope argument on that assumption.
That is my understanding of the position. I was...
It's just the last sentence in particular does seem rather striking, that D9 and D10 are bound by agreements at a stage where they haven't entered into a contract with anyone relevant. But that is the assumption we have to proceed on.
That raises questions of whether you adhere to the contract with retrospective effect.
I see.
Or not, and that again is matters that will all be determined when the parties aspect of the Section 9 dealing with beneficiary involvement or interference involvement is all worked out. But that is one, it is entirely possible, I have to accept, that when we come on to deal with that issue of Section 9, which would be in the autumn, some other outcome might be determined under Swiss law as to what is the effect. And that could be anything from the assumption that the parties, Republic and D9 and D10, were parties to all the agreements from, with retrospective effect, the dates of the agreements, or parties were Republic, or indeed D9 or D10 were only parties to some of the contracts, and if and insofar as they were parties to the contracts, from which dates. All of that is the matter of a subsequent debate, but it hasn't been addressed. And I appreciate not ideal for your lordships having to deal with it without that certainty, but that unfortunately is a product of the bifurcation of the Section 9, which has occurred.
Yes, that's a case management decision for which the court is responsible.
Sorry.
That's a case management decision for which the court is responsible.
Well, it's a case management decision, my lord, on any view, and of course, as case management decisions, they are virtually impossible to review. And so, understandably, these are matters that the courts have to deal with at first instance all the time.
Yes, of course.
They are where they are, and they lie where they lie.
Thank you.
So we have clarified or spelled out in our case at paragraph 12 that the appeal proceeds on the basis that the D9 and D10 are parties to all the arbitration agreements. So there shouldn't be any confusion or doubt about that. That's key bundle, page 77. And I don't anticipate that your lordships will be much assisted. I can give other references to where the matter is debated and developed and dealt with, but I don't anticipate that your lordships would find that a particularly productive.
No, I mean, you make the assertion at the bottom of paragraph 12, and I don't think it's been contradicted by the appellants.
And it raises issues of Swiss law as to how you can be found to have adhered to contracts in effect, even though you didn't sign them. It's all linked into the fact that although the Republic seeks to emphasize that its only position, its only contractual position is under the guarantee, its only interest is under the guarantee, in reality, as the supply contracts themselves recite, these contracts were all entered into for the benefit of the Republic, that the Republic should derive a benefit from them. And indeed, we say that they did, and had they used the equipment better, they would have derived considerably better benefit than they did. But on the assumption, which your lordships are invited to proceed, therefore, it is indeed the case that the Republic would be entitled to commence and pursue arbitration proceedings, such as it might wish, in order to have determined its claims against the respondents, insofar as they are within the scope of the arbitration agreements, because by definition they are parties to them. It is in that context irrelevant, although my learned friend touched on it this morning, that arbitrations commenced by the respondents in respect of the supply transactions have been dismissed by reason of difficulties of posting security for my clients. Those proceedings are about whether the Republic, these proceedings are about whether the Republic should be bringing its claims by arbitration and have nothing to do with any arbitrations that the respondents might have commenced, let alone any reason for those arbitrations having been dismissed. And we gather from oral submissions this morning that it is common ground that it does not matter at all whether there is or is not an arbitration on foot, or whether the party seeking a stay proposes to commence arbitral proceedings themselves. And may I just mention in this context that we have given your lordships a supplementary Dicey and Morris 16th edition, because by error the cross-reference to 16067 in our case was automatically linked to a 15th edition, which is erroneously loaded, so hopefully that won't be. The fourth introductory point I wanted to touch on is the centrality of the supply contracts to the claims. The key point, which the Republic artificially seeks to underplay, is the central role of the supply contracts in these proceedings. I'm going to come back to develop it in rather more detail in relation to the ground 2 stage analysis. Suffice to say at this stage, the Republic was not procured to enter into the guarantees as some independent third party in isolation from the supply contracts. The reality is quite the opposite. As you can appreciate, the supply transactions were the driver, concluded with and for the benefit of the Republic. The decision of the Republic to use SPVs and to structure the payment obligations of the SPVs by way of loan facilities guaranteed by the Republic is simply a route by which the Republic chose to structure the conclusion by it of contracts for the supply to it and for its use of the equipment covered by the supply contracts. All the relevant departments of the Republic in relation to fisheries and naval activity and secret intelligence were all involved in the negotiation process. The structure by which the transactions were then actually concluded and financed is a separate matter, but the thrust of it is that the supply transactions were the driver. They were what the Republic wanted. They recite in terms that they provide for benefits and services which the Republic wanted. They identify the reasons why the Republic wanted it, namely for the development of its economic zone, and in particular the fisheries and the protection of those fisheries. And so also the construction of shipyards to support those fisheries vessels and naval vessels. Now, what the Republic seeks to do is to assert, as we have seen, and I'll come back to develop it in a bit more detail, that the supply transactions were procured by bribery. And that case is clearly set out in the particulars of claim. It's recited by the Court of Appeal as part of its analysis of the true nature of the matters in respect of which proceedings have been commenced, and it is neatly summarised in the summary of the claim, which your lordships have in the bundle at page 419 at paragraph 26. And over the page onto page 420, up to paragraph 28, paragraphs 26 to 28. And its case is that the transactions were purportedly entered into, financed as they were, for the purpose of acquiring, in the case of the Pro Indicus transaction at 26.1, acquiring vessels and equipment to monitor and protect the Republic's exclusive economic zone, in the Amatum contract to develop a tuna fishing fleet and a land operations centre, and the sovereign guarantees were then secured as indicated, and at 26.3 the MAM transaction to create maintenance and repair facilities to repair the vessels, and so on. And what the Republic then says at 28 is all these transactions that involve the payment of large bribes to government officials of the Republic. They constituted a conspiracy to injure the Republic and thereby enrich themselves at the expense of one of the poorest countries in the world. Bribes or secret commissions were paid to Credit Suisse employees. Contractor fees were paid. And at 28.6, the bribes in the three transactions, including the sovereign guarantees, were together the key elements of a fraudulent scheme designed to obtain and to render the Republic liable for $2 billion. And that is the summary of the claim. That is what is disputed between the parties, and that is disputed not least in the way that I have indicated already, namely that our client's position is that this was not a scheme by which people would enrich themselves. It was a scheme by and with the blessing of the Republic, designed to achieve a benefit to the Republic by the supply of expensive equipment which my clients supplied, and which the Republic has since used and continued to use, though it is somewhat coy about how it uses them. And that, again, is an issue for the trial. But the net effect of all of this is that that is said to be the summary of the claim which my clients have to meet. That is what they are addressing, and it is, in our submission, entirely correct when the Court of Appeal suggests that against that background, it is very difficult to identify how it can be said that this case does not involve allegations of corruption in relation to the conclusion of the supply contracts. Now, the central issue in that context is the legitimacy of those supply contracts, and there will, of course, be extensive analysis and debate at the hearing, if it goes ahead in relation to my clients, as to the extent to which these supply contracts did result in the supply of valuable and useful equipment, what the value of that equipment was, whether in fact the equipment was of no value or necessity or need or benefit to the Republic, and also whether the circumstances in which all of these contracts were entered into, including the supply transactions as part of that package, resulted in very substantial macroeconomic losses for which the Republic claims, which are said to have arisen from the entry into these transactions.
But do you say that the validity of the supply contracts is an essential element of either the claim or a defence?
We say that it is both of the claim and of the defence, and I'll come back to develop that in more detail in the morning.
Right.
But in relation to these things, but we say that the Court of Appeal was correct in its analysis, and that is also why I say that there is really no significant issue of law raised on this appeal, because the Court of Appeal came to the conclusion that these issues were central to the actual proceedings before the court, and it was that test which the Court of Appeal applied. It was not a case in which the Court of Appeal decided that the correct test was, is it a peripheral is it a peripheral issue somehow arising or a tangentially arising issue because we think the test expands to that. You can see from the way in which the Court of Appeal approached it and expressed themselves, they were approaching it on the basis that this analysis was central to the issues that were concerned, both as a matter of claim and as a matter of defence. And so from that point of view, we say not only does a proper reading of the Court of Appeal's judgment not raise the issue of law, which is said to be engaged in this appeal, but anyway, the Court of Appeal got it right, and indeed they applied it correctly. And if one sees how throughout the Republic's claim, they set out the gravamen of their case on the basis of these transactions having been entered into as instruments of fraud, vehicles of fraud, corruptly, and in that context they have no, and they've accepted today, they have no independent case that the guaranteed part of it was somehow the product of some sort of independent corruption, whereas the other two bits, the loan and the supply contract, were in some manner not the subject of that. And the only basis upon which they really say, well, we proceed by way of the guarantee claim, because they say they're only parties to the guarantee claim. Well, we say, of course, that if we're right that they're parties to the agreements, then in fact they are parties to the agreements. And in those circumstances, they do have claims and rights under the supply transactions. But in any event, clearly, without the supply contracts, there would have been no guarantees. And if, as the respondents contend, the supply contracts are unimpeachable, then by definition, the Republic's claims against the respondents in respect of the guarantees will also parasitically fail. The respondents' case is simply that, as against the Republic, they should be entitled to have the legitimacy of those supply contracts resolved in the chosen forum of those supply contracts to which the Republic is party on this premise. And in their case at paragraph 9, the Republic raises the rhetorical question, assuming for the sake of argument that the supply contracts are valid, commercially sound contracts. So what? The answer is that in that case, the Republic's claims against the respondents will fail.
But would that include the restitution of bribes? If notwithstanding the commerciality of the contract, it was found that your clients had bribed Mozambican officials?
We say valid commercially sound contracts, or the rhetorical question is valid commercially sound. If there were bribes, then the supply contracts are not, or are potentially not valid, because they're...
Will they be valid unless they chose to terminate them?
Yes, but that issue is clearly engaged in the context of these proceedings. They are alleging that there are grounds by which they can get out of the guarantees, and if they were parties to the supply contracts, which we say they are and they say they're not, they would be able to get out of the supply contracts.
Yes.
And so...
I will be interested tomorrow to know why you say it's an essential element of the claim in answer to the analysis that bribery doesn't require proof that it had any inducing effect, the payment of the bribe and so forth.
Yes.
Or that the contract was not beneficial. None of these are elements to the cause of action in bribery.
I'll come on to that tomorrow in detail, but there are two things that one has to remember in that context. First of all, the attempt to suggest on the part of the Republic that one looks to the substance is usually the argument raised by the Section 9 applicant, because the case is being pleaded in such a way as to avoid the impact of the arbitration agreements. What here is happening, bizarrely, is that the Republic comes before you and says, don't pay too much attention to what I've pleaded. You can ignore all sorts of bits of it. They don't really matter. We say, as under the English law claims, you can't proceed on that basis. You can't say, as the claimant, ignore bits of my case, look to the substance of my case. We say we have to meet the pleaded case, and we're entitled, from the point of view of Section 9, for the court to look at it from the point of view of what are the issues engaged on the pleadings. There is, of course, a route by which the defendant, if the claimant has so cast its pleadings as to obscure the true nature of the transaction, can say, well, other than what's on the pleading, you also have to take into account that the true nature of this case is X. But that's not a get-out card for the claimant who has pleaded his case in a particular way and now wants to avoid the consequences of that. The second point in relation to it, of course, is the implications of Mozambican law, which is different in relation to bribery.
Yes, but the authority that says you're to look at the substance of the matter will apply to both parties, won't it? You can say you must look and see how it's pleaded, and that is part of the substance. And the Section 9 applicant quite often will say this is fancy pleading to ignore the substance.
Yeah.
But at the end of the day, we're looking to the substance, and you're saying part of the substance is the case that's pleaded against us.
Yes.
But you're not denying that substance is the subject for which we are directed to look for.
What I'm saying is that a Section 9 applicant is entitled to say, this is the case that's pleaded against me. I have to meet that case. But there is also, in substance, some other case which is somewhat obscured by the way in which the case is being pleaded. It is not open to a claimant to say, I've pleaded my case in this way. I don't like the way I've pleaded it because it causes me problems with the arbitration agreement. So please ignore unidentified parts of what I have pleaded, brackets, any bit which is inconvenient to me, in order that you look, please, at the substance rather than what I have actually pleaded. That's not a path open to a claimant. So in that sense, I don't accept that it works both ways. What is incumbent upon the court is to look at the case that the respondent has to meet, both as to the pleaded case and any substance of it which has been obscured or not fully pleaded.
It's a bit odd that a different test is applied depending on who it is who prays in aid the test, but we can discuss that tomorrow.
Very good.
Thank you very much. The court will now adjourn.